I note Commissioner Mashinini, Commissioner Love, the chairperson as well of the Independent Electoral Commission, and I'm not sure if I'm missing anybody from the commission, the officials. Okay, welcome to this meeting, and I think officials as well from the parliamentary legal team, the state law advisor as well. Honorable members, welcome, and just for the record, I just want to go through in terms of who's present. We have Honorable Maleka, Honorable Fissa, Honorable Dodogo, Honorable Mikalakis, Honorable Siliku, Honorable Matsamai, Honorable Dlamini, Honorable Bartlett, Honorable Ndongeni. Okay, and I hope once again I'm not missing anyone else on the list. But once again, welcome honorable members. Honorable members, just in terms of our previous meeting that we held on the 21st of November, we considered proposed amendments to the Electoral Amendment Bill, and after deliberations, we requested the legal teams to refine some aspects of the amendments, especially with regard to the clause relating to broader electoral reform, also be considered as a transitional provisional clause, and that the clause would be reflected in the amendment bill and not in the principal act. Our meeting today, the state law advisor will present the refinements that has been made on the proposed amendments, and I think thereafter members will be given an opportunity to deliberate and or confirm the refinements that have been made. However, with regard to the possible adoption of the clauses, I think we will defer that to our meeting on Friday, which is likely to be the last committee meeting on these matters. And at that very same meeting, we will also deal with the adoption of the committee report, and if that is also agreeable to all members. But I think it would be feasible to actually do both in our meeting on Friday. I think with that being said, let me then hand over to the state law advisors then to take us through the refined amendments. Over to you.
Thank you, Chairperson. Good morning, Chairperson. Good morning, Minister. Good morning, honourable members and commissioners present. Chairperson, the Office of the Chief State Law Advisor, together with Parliamentary Legal Services and together with the department as well as the ISC, we considered the previous drafting. We've considered the draft for the review committee as proposed by the department, the Electoral Reform Consultation Panel. We looked at that. What we basically did to the drafts, we basically simplified it. We made it, we redrafted in a manner which makes it more simple, easier to understand and comprehend. Okay, so Chairperson, would you prefer that I only go through the changes that we made because the substance is essentially the same as we presented on Monday? I can go through the changes, or would you like us to go through the entire draft?
I think it would be maybe more feasible if you just go through the changes, because I think in terms of what we discussed, then the amendments or the refinements referred to clause 3 and 6 and the new clause, if I'm not mistaken. But you can just take us through how you refine some of these things. But members did receive the document as well yesterday after the team sent it to us, and yeah, and then I'm sure we'll engage after that. Thank you very much. Please continue.
Okay. Thank you, Chairperson. Okay. The first redrafting we did was in respect of clause 3, item 3, the proposed insertion of paragraph CB. What we basically did, we we divided that clause into, we divided the subparagraph into two
my apologies.
Subparagraphs. Sorry.
Can I propose that we reflect the document as well? It just makes it easier for members to follow. I'll request be it Gershwin or Zolani, whoever can assist with that. I think it just assists us to see what you're also saying, because I'm not sure if members have their multiple gadgets open and are looking at the documents. Gershwin or Zolani, can somebody assist with that?
I'll assist.
Okay, great, thank you. Soraya, you may continue.
Thank you, Chair. Okay, if you can proceed to clause 3, which is the first clause in the document. Thank you over there. Yeah. Paragraph CB, further down. Yeah. The subparagraph I, if we can go further down, that paragraph would now read, we divided it further into two further subparagraphs. It would now read, in the case of an election of the National Assembly in respect of regional seats on the national segment of the voters' roll and who support the party. And then we have a subparagraph AA, totaling 20% of the quota for the region in the preceding election when nominating candidates for one region, or totaling 20% of the highest of the regional quotas in the preceding election when nominating candidates for more than one region. And then with regard to subparagraph 2, we've just fixed the grammar there. So to read, in the case of an election of a provincial legislature on the segment of the voters' roll for the province and who support the party, totaling at least 20% of the quota of that province in the preceding election for which the party intends to nominate candidates. Those are the changes in respect of clause 3. It doesn't change the substance. It just lays it out, sets it out more clearly. Then with regard to clause 6, the next change would be in paragraph A, subparagraph 1. Yeah, it would now read, in the case of an election of the National Assembly in respect of regional seats on the national segment of the voters' roll and who support his or her candidature. And then a further subparagraph AA will be totaling 20% of the quota for that region in the preceding election, comma, if intending to contest only one region, or subparagraph BB, totaling 20% of the highest of the regional quotas in the preceding election if intending to contest more than one region, or subparagraph 2, in the case of an election of a provincial legislator on the segment of the voters' roll for the province and who support his or her candidature, totaling at least 20% of the quota of that province in the preceding election, which the independent candidate intends to contest. That's all the amendments for that. With regard to clause 21, we haven't made any changes or redrafting to clause 21. Chairperson, I am accompanied by my colleagues, Ms. Sarah Govender and Ms. Aisha Johar. Ms. Sarah Govender will go through the new clause. That's the clause as proposed by the department. As the chairperson said earlier on, it would be a clause which would remain in the Amendment Act, and it will not form part of the Principal Act. And to give effect to that, we have redrafted the heading to the clause. I'll hand over to my colleague, Ms. Sarah Govender. Thanks.
Thank you, Chairperson. If we could just go to page 7 of the list of proposed amendments. Thank you. Towards the middle of the page, new clause. On page 19, this is page 19 of the bill, after line 12, to insert the following new clause after clause 22, and to renumber the existing clause 23 as clause 24.
Ms. Govender, there's an echo. Do you have another device which is also logged into the meeting? Ms. Govender, we can't hear you. Can you please unmute yourself? Ms. Govender. Is it just myself, colleagues, or can you not hear her?
We cannot hear, Chair.
Okay, Ms. Govender, two issues. Well, firstly, unmute yourself, which you've done. The second issue is that when you speak, there's an echo. I suspect you might have more than one device logged into this meeting. If that is the case, can you mute one of the devices, or can you? And we can't. Can you unmute yourself? We cannot hear you.
Chair, she's gone. She appeared on the screen momentarily and disappeared again. I think she has got problem with connectivity more than anything else. She appeared momentarily and she's gone again, so she can't hear you.
Okay. Ms. Williams, are you able to then deal with this matter, or should we wait for Ms. Governor?
Sorry, Chairperson, I seem to be back if I'm using my earphones.
She's back.
Am I more audible now?
Yes, you are.
Okay. May I proceed?
Please start from the beginning of what you said. Thanks.
Okay. On page 7 of the list of proposed amendments, the new clause, which will be inserted on, which will read as follows. On page 19 of the bill, after line 12, to insert the following new clause after clause 22, and to renumber the existing clause 23 as clause 24. Clause 23, Electoral Reform Consultation Panel. Within 4 months after the commencement of this section, the Minister must establish the Electoral Reform Consultation Panel. 2A, the functions of the panel are to independently investigate, consult on, report on, and make recommendations in respect of potential reforms of the electoral system for the election of members of the National Assembly and the election of members of the provincial legislatures in respect of the elections to be held after the 2024 elections. B, the panel must perform its functions referred to in paragraph A in a manner that enables Parliament to exercise its constitutional powers to determine the electoral system for the elections of the National Assembly and provincial legislatures in respect of the elections to be held after the 2024 elections. 3, the panel must A, prior to the 2024 elections, engage in research and consider the issues falling within its functions. B, after the 2024 elections, undertake a public participation process regarding the issues falling within its functions. And C, from the date of its establishment, submit a report to the Minister every 3 months on its progress. 4, the panel must, within 12 months of the date of the 2024 elections, submit a report to the Minister on the possible options for electoral reform for the election of the National Assembly and the election of the provincial legislatures, which must include A, reasons, potential advantages and disadvantages, B, legal and constitutional implications, and C, financial implications for each proposed electoral system or electoral reform identified by the panel. 5A, in the event that the panel is unable to submit the report contemplated in subsection 4, the panel must, no less than 3 months before the date on which the report is due, make a written request to the Minister to allow the panel an extension of no longer than 6 months to submit the report. B, the Minister may, upon receiving the request referred to in paragraph A, grant the extension on good cause shown, provided that such an extension may only be granted once. 6, upon receipt of the report contemplated in subsection 4, the Minister must, within 30 days, table the report in Parliament for its consideration and publish the report through electronic and any other means. 7. The panel is authorized to do all things necessary or incidental to fulfill its functions, including A, to call for and receive written submissions from political parties, independent candidates, civil society organizations, and any interested person or party in respect of potential reforms of the electoral system, and B, to make the written submissions publicly available and accessible through electronic and any other means. 8. In order to establish and constitute the panel, the minister must A, call on the public and any interested parties to nominate fit and proper South African citizens who, 1, have the necessary skills, expertise, experience, knowledge, or academic qualifications in the administration and running of elections or constitutional law or electoral systems. 2, are not members of parliament or any provincial legislature. And 3, have not, in the past 12 months, been office bearers or employees of any political party. B, in consultation with the Commission, appoint 9 members of the panel from such nominated persons who satisfy the criteria specified in paragraph A, and appoint one of the appoint one of the members of the panel as the chairperson of the panel. 9. A member may resign from the panel by giving the minister A, 1 month's written notice, or B, less than 1 month's written notice with the approval of the minister. 10. The minister may, after taking the steps required by subsection 11, remove a member of the panel if that member A, committed an act of misconduct, becomes incapacitated or is incompetent, B, is unable to perform his or her functions for more than 30 consecutive days, C, acted contrary to the fulfillment of the panel's functions, or D, neglected to perform the functions as required by a resolution of the panel. 11. Before removing a member of the panel in terms of subsection 10, the minister must afford the member an opportunity to make written representations and must consider those representations. 12. A, should a vacancy arise in the panel, the minister, in consultation with the Commission, must fill the vacancy from the persons already nominated in the process contemplated in subsection 8A. B, in the event that no suitable person can be appointed, the minister must undertake a new nomination process as provided for in subsection 8A. 13. A member of the panel who is not in the full-time employment of the state must, A, be appointed on such terms and conditions as the minister may determine, and B, receive such remuneration and allowances out of the funds appropriated for the functioning of the panel as the minister may determine in consultation with the Minister of Finance. 14. The Director General of Home Affairs must, subject to the laws governing the public service, A, appoint, second, or designate persons in its employ, and B, make available any other necessary resources to assist the panel to enable it to perform and fulfill its functions. The minister, 15, the minister must dissolve the panel, A, after the minister has tabled the report referred to in subsection 4 in Parliament, and B, once the minister and Parliament no longer require the panel to perform any of its functions. 16, and these are the definitions as used within the section. A, 2024 elections means the elections of the National Assembly and the provincial legislatures due to be held during 2024. B, minister means the cabinet member responsible for home affairs. And C, panel means the electoral reform consultation panel established in terms of subsection 1. Thank you, Chairperson. Those were the extents of the proposed amendments to that clause in respect of the electoral reform consultation panel. Thank you, Chair.
No, thank you very much, Ms. Govender and Ms. Williams, for that presentation. I think on members, you can't agree with me more that it has simplified the drafts. It has made some of the issues more explicit. And I think there's also been some improvements in terms of the new clause relating to the panel. Let me then open it up to yourselves, honourable members, if you have any comments and or questions or any additions that you would want to make. There is something that I would like to raise, but I would want honourable members to first raise their issues. Honourable members, over to you. Okay, I'm not noting any hands. I take it, honourable members, that you are satisfied with what has been presented. Honourable Mikolakis, I see your hands up for now. You may continue.
Thank you, Chair. It is not an indication whether myself and my colleagues from my party support this specific addition, but what I do want to say is that it resulted from questions that both you and I asked, and I do feel that we can really just thank everyone who was involved in trying to make some of these aspects more explicit. And acted on those questions of ours. So just as far as that is concerned, I do want to express my thanks to them as well. Thank you very much.
Thank you very much, Honourable Mikolakis. Honourable Bartlett.
Thank you, Chair, and sorry for not switching on my video. Chair, I just want to make a few observations on Clause 3 and Clause 6. These clauses address issues of equity in the manner that the bill treats both independent candidates and party candidates. With regard to the support amendment layout of the clauses, makes the reading of the 20% or the highest regional quota more explicit. And then secondly, Chair, with regard to the new clause on electoral reform consultation panel, there have been improvements as quarterly progress reports by the panel to the minister sets out processes that the panel needs to follow if they're unable to submit the report in 12-month period, and that needs to 3 months before the due date request an extension for a period not longer than 6 months. And then lastly, Chair, the removal of a panel member by the minister allows for due process in that the minister must afford the member an opportunity to make a written representation which the minister must consider. It's only a observation that I'm making, Chair. Sorry. Thank you very much, Chair.
Thank you very much, Honourable Mikolakis and Honourable Bartlett, for those observations.
Honourable Chair,
Honourable Dodovu.
take me to paragraph 15. I want to propose something. If you can.
Okay, I'll request, I'm not sure who was projecting the document. Could you please do it again? Was it Gershwin or Zolani? I'm not sure, one of you.
The B thereof speaks to the time that the minister dissolves the panel after completing its work. I want to speak to that. Yes, you can see that B speaks to the fact that once the minister and parliament no longer require the panel to perform any of its functions, I would like to propose C. And the C must speak to what happens with regard to the members of the panel once they have completed their work. My proposal is that we must insert a clause that specifies that once they have done doing that, they are not allowed to make some public comments unless they are required to do so by Parliament or by the minister. We had this experience that once members have done their work, they have participated because they were appointed to serve in particular structures. Once they do that, they deviate and get out of the report itself that they have submitted. And my proposal in this regard is to indicate that once they are done with their work, they are not allowed to make comments outside the scope of the report that they would have submitted to the minister and thereafter Parliament. I want to add C, that speaks to that. The prohibition of members of the panel. Thank you, Honorable Chair.
Thank you very much, Honorable Dodovo. Honorable Mikalakis, do you want to speak on the same issue?
Yes, please, Chair. Chairperson, I do think that we need to keep certain basic principles in mind, and freedom of speech is one of them. I do understand that obviously there will only be one official report, but that should not bar individual members from expressing their own views. Obviously, I think the public firstly has an interest in knowing the workings and deliberations going on within the panel. So there's a public interest involved in it, but also, I mean, individual members of the panel should be able to express their views freely and openly, just as Parliament's committee reports allow for dissenting and minority views, the same with court judgments. So to say to members of the panel that they're completely barred from differing and expressing their views, I think would be fundamentally undemocratic. It does not take away from the fact that there is only one official report, and that is the majority view of the panel in the end. But I do think that the public and all of us are mature enough to understand the difference between an individual view and the report of the panel, which is a collective view. So I do think we need to be very careful in considering things like this, not to put in things that might not ultimately pass constitutional muster. Thank you very much.
Thank you, Honorable Mikalakis. Honorable Professor, is it on the same issue?
I support that we have in mind and be mindful about that. Thank you.
Honorable Professor, you are not very clear. My apologies. I couldn't hear you clearly.
Okay, I'm supporting Honorable Mikalakis because we have to be mindful of that freedom of speech and stay within the perspective of the Constitution.
Okay, no, that's fine. Honorable Matsama, your hand was up.
Yes, Chairperson. Chairperson, I was just listening to the minister last week, and I even read and think about this issue. I think this is very serious, and I think we must return this bill back to the National Assembly and for them to deal with this issue, because this is very it's traumatizing us. I mean, it's very, I don't really understand about this. So that they can give us a light from that side.
Okay, no, thanks, Honorable Matsama. Honorable Dodovo.
Oh, no. Yes, Honorable Chair, can I just develop my point further? And please, if members want to engage with that, they are free to do so. We have a practical experience, Honorable Chair, and that is why we are here in respect of this bill, that some members of the ministerial committee, the committee that advised the minister on this bill, they were afforded an opportunity to participate in the process. They called for submissions or the methodology, whatever methodology that they followed. And at the end of the day, they produced a report. And in the course of doing their work, they acted in a confidential way. And in some instances, the deliberations that they had were private and confidential. Now, at the end of the day, they present a report after having voted, because it is quite clear that members of that committee were not in agreement. What do? You participate within a committee, you present a report, and before you present the report, you even vote, expressing your views. Now, it is our time. It is our time, members of the public. It is our time, members of parliament, to deliberate. But you sneak yourself. You find yourself right at the center of the public debate when you are afforded that opportunity. Is to confuse us. And I'm saying in this particular instance, the minister will appoint a 9-panel member, and as it were, they are going to do an extensive work. They are going to do extensive consultations. They are going to research. They are going to deliberate at the end of the day. They are going to compose a report that will bring to the attention of the minister. And maybe, I'm not sure, in the course of the report, they will do what Honorable Mikalakis is saying. They will express their views. They will dissent if ever they don't agree with certain things in the report. And at the end of the day, they will present the report to the minister. The minister will present the report to the public and to parliament. Whilst we are now there, we allow public participation, we allow people to contribute. You become the first one who's raising your hand and want to participate in the process. And remember, by that time, you would have had confidential and even private discussions and documents and other related material pertaining to the committee that you would have served to the panel that you would have served in. What do? Now you get into the public space. For me, it's not only applying double standards of selective morality, but I strongly feel that it is not acceptable. And all that I'm saying in terms of my proposal is to say, yes, you are allowed to speak. And this constitution, our constitution, will not deny any person the right to speak, to express their viewpoints. But all that I'm saying is that you will do that through the proper channels which created you. And in this particular instance, it is the minister who takes the report to parliament. And I will never in any way stand here, violate the freedom of speech that is clearly entrenched in our constitution, that everyone has got to speak. But even that freedom of speech has its own limitations. You don't just speak because you are entitled or you have the right to speak. It has limitations. And all that I'm saying is that give us a space, allow the 60 million people of this country to speak, because you would have been afforded that opportunity. And that is why I'm careful in terms of my proposal. And my proposal is that, yes, do that, but do through the minister, because as I'm saying, you would have had private and confidential information, discussions, and even documents pertaining to the work that you would have executed over a period of time. And in this case, from now until 1 year after the 2024 elections are held. And that's all that I'm requesting the committee to consider, because for me, this is quite important. We don't want confusion in terms of what we want to do, but at the same time, we don't want to limit the rights of people by not saying that they must speak, but they must speak through the proper channels. Which channels have created them? That's what I'm putting forward, Honorable Chair. I'm sure the lawyers in this instance can advise us to say, if you do that, you either encroach on the rights of people that are enshrined in the Constitution or not. But for me, this is the crux. And from that point of view, we could get a clear opinion or view whether what I'm proposing, it is outside the boundaries of the law or not. Thank you, Honorable Chair.
No, thank you very much, Honorable Dodovu, and all honorable members that have raised views on the matter. I think what you raised, Honorable Dodovu, is a very important principle. And I think it was also raised while we were busy processing the bill. But I think it's also important that the constitutional implications of including this in the bill must be considered. And I'm not sure if legal would want to say something about this at this point, but let me ask legal if they would want to. Honourable Minister, Honourable Minister?
Yes, before legal speaks, because I want them to speak to a similar related point, which I want to propose to the committee. The issue, Honorable Dodovi has just mentioned about a panel where all members do not necessarily agree on one thing, and they started voting. Now, that type of thing, yes, he's right, did happen when this very same bill was being enacted by the committee that was chosen by the minister. Now, I want to ask the legal team to help us. How does this committee make its decisions? Because that's very important. Is there an issue of majority and minority? Chairperson, this is very important for me, because when this bill in front of you was enacted, the public was told by a majority and a minority, which I can tell you legally did not exist. They did not exist, but the whole country is knowing that the minister ignored the decision of the majority. And I was shocked, because when we did terms of reference, there was no issue of majority and minority. It was silent. So I don't want you to be silent on this. How does this committee take decisions? Do they vote? And is Parliament, because in the terms of reference, it says they must write advantages or the pro and cons of each proposal they are put into Parliament, which means they might put more than one proposal. That's my understanding. Now, is Parliament going to rubber stamp what is called a decision of the majority? Or are they going to look at all the proposals equally and say, as Parliament, we think the most suitable one is this, after the committee has reported? This must be clarified, because I can tell you it caused confusion. Is there a majority and a minority? Is there voting in this whole thing? Now, the second thing, which was raised by Honorable Dodovu, where I can hear Honorable Michalagis is saying, it restricts freedom of speech, but he gave an example of judges. In the Constitutional Court, or where judges sit in what they call a full bench, you don't hear a judge coming out and tearing apart the decision of the others where he was involved. In the IEC, I'm sure you know you have got 5 commissioners, and all of them are here except Judge Pillay, who I suspect is in court. All the commissioners are here. You have never had one of them coming out and saying, I never agreed with this decision by my colleagues, once the decision is made and passed. And the third thing in this regard, if a person feels that they want their freedom of speech as members of the public, then they must decline when they are appointed to this committee and say, no, I want to participate freely as a member of the public without any impediment. So don't put me into this panel, because at every available opportunity, I'm going to be speaking loud and clear. That will be fair. And fourthly and lastly, if a member finds that this panel is going astray, doing things that they don't agree with, that member cannot allow the report to come out public and come and attack it. You must do it there and say, look, I'm no longer part of this report. I don't agree with what you are reporting to Parliament, and I'm pulling out, and make that public, or that I'm pulling out because I don't agree with the direction. But to agree with it, and when it goes out, start attacking it, it causes confusion in the public, because they don't know what happens internally there. So I want Parliament, I want this committee to look at this issue. These are very important issues as far as I'm concerned, and Honorable Dovu cannot just be dismissed like that. Otherwise, we are going to have these problems again, because this is a very, very a contentious matter which everybody wants their way about what must happen. Thank you.
Thank you very much.
And Chairperson, just for a second, sorry. My apologies, my deepest apologies, Chairperson. Because there's been a proposal that the legal team must help. I happen to know in law, there is something called functus officio. It's not exactly what Honorable Dodov is saying, but there is a principle like that, functus officio, that you did present a particular report and you gave it to the relevant people and you pull out, you can no longer talk about it. I know it's a legal principle where the person who is regarded or a committee who is regarded as a functus officio have got decision-making powers, but they are more or less the same. That's why you don't hear judges, you only hear Zondo coming back and talking about the report he has submitted to the public. It's been debated. Some members of the public are tearing it apart, others are accepting it, but you don't hear him coming in and entering the debate. And that's a very good principle, even though it's a principle of law for a committee that has got decision-making powers. The lawyers must tell us whether it applies in this case. Thank you very much.
Thank you very much, Minister. I think what also comes out from your input and also that of Honorable Dudovu relates a lot around how does the panel take decisions and how do they communicate those decisions. But with regard, I would maybe ask legal to perhaps assist on this. If they have any comment to make here and now, they may, but if they would prefer that we refer it to them so they give us the necessary advice on it, that they then do so. I have De Beer, Mitchell De Beer, Senior Counsel. Yes.
Not senior counsel, junior counsel, but counsel for the department. What I would suggest, perhaps the legal team can have a look at this, and just give it a consideration. What I just do want to emphasize is that the purpose of the panel is to make recommendations, because of course Parliament, and that's why I can't remember which provision it is, but the purpose is to enable Parliament to make decisions, and the panel is making recommendations. But as I say, I think on the two questions as I have it, one is the question of the actions of panel members once it's been finalized, and two, the decision-making process of the panel. I think if we can just have an afternoon's look at it, that'll be good. Thank you.
Okay. All right. No, thank you. I think then perhaps we'll leave that with the legal teams to look at that, and I'm hoping that you're able to come back to us by the end of today, so that on Friday we actually, it's possibly the last meeting of the committee in terms of processing this bill. We're able to then process matters accordingly. The other matter, I don't know, honourable members, do you have any other issue to raise? If not, I'd like to just raise one matter which comes to mind now, given that the clauses in clause 3 and 6 have been made more explicit, and which I think might be a gap, but perhaps if we can get an explanation on that. And this is with regard to what happens if an independent candidate does not meet the 20% requirement of the highest regional quota, and yet they intended to contest all 9 regions. My question is, how is this matter addressed in the bill, or is it addressed in the bill? And perhaps I think the IEC could perhaps respond to that. Yeah, please, maybe if I can get a response maybe from the IEC on that one. I hope you understood what I asked. Commissioner?
Thank you very much. Yes, thank you very much, and good morning to you, and the minister and everyone that is present on the platform. You raise an important issue. It is implied, but it's not specified in my view. I take the point, and I'd like to invite the CEO and his team or my colleagues. I think you make a good point. It is implied, but it's not really specified. If they think that we can get around it, let them say. But I think you're raising an important point that we need to look at. Commissioner Love, Sai?
Thank you, Chair. I'm not sure if Commissioner Love would like to come in first.
No,
CEO, I think come in. If there's anything, I'll add, CEO.
Thank you very much. Greetings, Minister Chairperson. Indeed, it's an important point that the Chairperson of the committee is raising, and that is not explicitly addressed in the current draft. The best way, in our view, to deal with this is that obviously, if they don't meet the 20% of the highest quota in the previous election, then it means we'll have to assess them on the second highest. And if they meet then that one, then they qualify for the rest, but they don't qualify for the highest. So in a sense, what I'm saying is that let's take the current situation. Gauteng has the highest quota at 92, and 20% of that will obviously be the highest of all the countries. Now, if a party or an independent wants to contest all 9 regions, and they submit supporting signatures, but they don't meet the 20% in Gauteng, it means that party or that independent will be disqualified for the Gauteng regional ballot. Then we will assess whether they meet the 20% in the second highest, and make a decision in that way. And that will be true for the rest of the quotas going down. So, Chair of the committee, if the committee accepts that principle, then we can also refer it to the legal teams to include in Section 31 and as well as Section 27 an additional clause to deal with that principle. Thanks.
Thank you very much, CEO, for the response. Are there any other issues? Okay, if there are no other issues, then I would request. Oh yes, I was going to come back to legal. Ms. Njikela?
Good morning, Chair. I'm sorry, I may have been moved a little bit ahead of myself. I didn't know you were going to come back to us, because there is one particular issue which we would like to raise that relates to the issue of the time frames and the deadline of the Constitutional Court. I don't know if I should do it now, Chairperson, or you will do it after you have dealt with it. But I thought you were closing, so I apologize for that.
Okay, no. I was just closing on what members were saying, and then we would then come to the legal teams if you have any comments. But please, Ms. Njikela, you're on the platform. You may continue. Or I would have preferred you come in last. I would have just started maybe with the other legal teams. Whether they have any.
I can do that, Chair. I just thought we were at the end.
Okay. No, it's fine. I think we are at the end. It's just, Ms. Njikela, maybe you can come in. Thanks.
Chair, you will recall that in the last meeting, there was the issue that came up with regard to the Constitutional Court deadline, which, as we all know by now, is 10 of December. And as the committee would have noted, there are a couple of things that have come up that may have an impact on the issue of us being able to meet the deadline. And as a result, as the team, we've been exploring the possibility of seeking an extension as discussed in the last meeting. And having looked now at the timetable of the Constitutional Court, from what we understand, the deadline is likely to be the 30th of November. That's the last case they will be hearing on the matter. So we just thought we should highlight, of course, maybe I should also say this, that when you look in terms of what is being said in terms of the timetable that they have circulated, is that a matter can be accommodated on the instructions of the Chief Justice. But that is a bit risky in the situation that we are in, given that if we are not able to meet the deadline of the 10th, it may likely reflect badly on Parliament. That's why we were mulling over the idea of applying for an extension. So there is that dilemma that we are facing at the moment.
Ms. Njikela, there are some points when you speak, I cannot hear you clearly.
I'm sorry, Chair, this is the problem I've been having in the last meeting as well. It seems like something is wrong with my laptop. How is it now, Chair?
No, you sound much clearer.
Yes. Chair, I was just saying, in view of the deadline, which is the 10th, and given the issues that have come up now, there is a real likelihood that the processes of Parliament may not be finalized by the 10th. Given that we are here now and there seems to be matters that will have to be referred back to the NA, as it was discussed in the last meeting. Whether that is possible within the 2 weeks, and I think I'm correct, it could be just a day under 2 weeks, whether it's possible for us to meet that deadline of the 10th. And it was in that context that the issue of a possible extension of the deadline was raised. So we just thought, Chair, we should raise it with you. It may not be the right moment for us to make a decision, but I think we need to be alive of that issue. That is an issue that at some point, and hopefully soon, we can make a decision as the committee so that the legal processes can be initiated in good time. Chair, with your indulgence, I don't know if my colleagues, Daksha and Telana, would like to add anything on that.
Is it on the same matter?
Yes, Chair, I was just saying if there is something I may have left out, with your indulgence.
Okay.
Grant them an opportunity.
Daksha, Telana?
Good morning, Chair. Good morning, members. I think Mr. Chikela has covered everything. Thank you, Chair.
Good morning, members. Chairperson, through you. Just one point that Mr. Njikela had left out is that the Constitutional Court has in the past lambasted us for applying for extensions too late. And just to reiterate what he said, that the last day of the court roll is on the 30th of November, and that we have spoken to the IEC and that they have no issue with the request for an extension within reason. So, and we've also discussed it with counsel for the department and that they would be in support of such an extension.
Okay, I'm going to take that as in the committee becoming aware of the timeline. I think we've tried everything in our power to process matters as quickly as we could. And clearly we've come to a point where there are proposals or proposed amendments on the table. And our intention is that in our next meeting, we actually deal with the adoption of these. And I think in terms of the program of the NCOP, this bill is expected to be tabled on the 29th of December. And I'm just hoping that process, well, we've tried to the best of our ability to try and assist the processes that need to be undertaken by the portfolio committee. Well, I hear the concern, and I think that this is also a broader matter for Parliament in its totality to try and address this. And hopefully this matter will also be elevated within the institution. But I think from our side, I should just tell the legal team that we're trying to get this bill off our table so that it gets into the NA process. And because, I mean, we wouldn't want to preempt what the portfolio committee actually does with our proposed recommendations. But that being said, I think we've heard the suggestions, and I don't know if it's within our powers to actually instruct that these processes get initiated. But I would imagine that there is a possibility that the portfolio committee would accept our proposals, and then the need, obviously, to go back to the Constitutional Court with regard to those kind of deadlines. I think with that said, let me just thank everyone. Thank the minister, the commissioner of the IEC, and all commissioners present, the deputy minister as well, all members of the committee, and all staff, including the legal teams from the state law advisors, the Department of Home Affairs, the IEC, and Parliament Legal Services for your attendance and participation in this meeting. I think we would expect that hopefully by the end of today, you're able to come back to us around those two matters, and so that committee members can, before Friday, look at these proposals, and on Friday, we can then look into the adoption of these clauses, as well as the committee report. With that said, thank you very much. Let me then also take this opportunity to request that the minister and the IEC and the legal teams, you can be released from this platform. We're going to take a 2-minute break because Honorable Zadobu will actually take over to deal with matters related to the Select Committee on Cocta Human Settlements, Water and Sanitation. That being said, I think Minister, Commissioners, and the legal teams, you may be released from this platform, and thank you very much.
Thank you very much, Chair.
Thank you, Chairperson. Thank you.
Thank you.
Thank you,
very
Chair.
much. Chair.
Bye.
Thank you. Bye.
Okay, members, 2 minutes, and then Honorable Zadobu, you take over.
It's okay, Chair. I'll do that. Honorable members, welcome back to this meeting. We are proceeding. As Honorable Sheikh indicated, we are going to be on the session of the Select Committee of Cocta Human Settlements, Water and Sanitation. That is what we are going to do. In terms of the agenda that is before you, we have only basically 2 items. We will not deal with the opening and welcome. Honorable Sheikh in the first meeting did that, or if you want me to do that, you are heartily welcome to this meeting now of Cocta, Human Settlements, Water and Sanitation. And apologies as reflected in the first meeting. Basically, there were no apologies recorded for this meeting. We are going to deal with 2 items, and these items are about the reports. The first report being the oversight visit to the Free State, specifically the Malutia Pofung local municipality. And in this regard, we want to consider and adopt the oversight report pertaining to that municipality. The second one relates to us considering and adopting a consolidated report in respect to the oversight visit that we had to Mpumalanga province in respect of Section 106 investigations report that we went to Mpumalanga to deal with. In that sense, I'm going to request Moss to then present the first report so that we deal with that first report.
Thank you, Chairperson. Mr. Holiday, can you put the report on the screen, please? Chairperson, thank you very much for giving me an opportunity to present the committee report. I just need your guidance, Chair, whether should I read the entire report or should I focus on observation and recommendations?
I propose, if you don't mind, because you circulated the reports to all members at hand, they know that we went to Malutu, Apofu, for example, on around the 16th of August 2022. They know the objective to go take us through the observations and recommendations.
Thank you, Chairperson. Go down, Mr. Flay. Yes, thank you. Thank you, Mr. Holiday. Once more again, thank you very much, Chairperson, for giving me this opportunity. Honourable members, this report deals with observation on Section 9. Section 9.1 reads as follows. It was identified that the municipalities was placed under administration in terms of Section 1391B of the Constitution on the 10th February 2018, after a series of unrest within the municipal area, specifically in Kwalko. There were various administrative and service delivery challenges in terms of the monitoring and oversight actions performed by the Department of Cocta and serious financial problems as contemplated in Section 138 of Municipal Finance Management Act of 2003. This includes raising of ESCOM debt to the tune of 2.2 billion, non-payment of third parties amounting to 206 million covering pensions, medical aid, Auditor General's report, and insurance policies. 9.2 reads as follows. Consequently, the Free State Department of COGTA has withdrawn the intervention in the municipality in terms of Section 1391B of the Constitution and invoke instead Section 13915 to assist the municipality with the development of financial recovery plan, including support in terms of Section 154 of the Constitution. This was based on the assessment done, which revealed that institutionally the municipality was stable. 9.3, the Select Committee has further noted the general concerns raised by the internal and external stakeholders on matters related to lack of Section 139 intervention impact, poor leadership, political instability, poor service delivery, stealing of municipal property, unfair tender practices impacting on women, non-tabling of impact reports to the council, non-functioning of some of the Section 80 committees, poor consultation, and public participation of some wards, and non-implementation of the resolution of local labor forum, absence of service delivery budget implementation plan, and slow process of filling critical vacant positions. 9.4, the Select Committee has observed that most of the municipal strategic documents which are relevant for local economic development, an example, local economic development strategy, tourism sector plan, agricultural sector plan, investment policy, revitalization of shopping center, waste collection, agri-village, feedlot, fodder bank, abattoir are still at the conceptual and initial stage. 9.5, the Select Committee has noted with serious concerns that despite the capacity building program of SALGA to capacitate members of MPEC, the latter, meaning the MPEC, is failing to table reports to the Council for consideration and adoption. 9.6, the Select Committee has noted that the general concerns raised by the stakeholders resolved around dysfunctionality of the municipality, poor municipal leadership, criminality of municipal property, non-functioning of some of the Section 80 Section 80 committees, non-tabling of reports to the council, unfair tender allocation practices, lack of consultation and public participation at what levels. 9.7, the Select Committee has noted and welcomed the executive decision undertaken by the Deputy Minister of COGTA to provide support and revisit the local municipality. Just a short background, members, you'll recall that Deputy Minister was part of our oversight visit, and the Deputy Minister made an undertaking to support or to in future engage with the municipality in order to provide support. This is the context of this observation. 9.8, the Select Committee further welcomed the partnership that has been established by ESCOM, SALGA, COGTA, and local municipalities to address electricity crisis, debts, revenue generation, technical and financial sustainability, and commitment of the Department of COGTA to comply with all treasury requirements for approval. 9.9, the Select Committee has further noted that the local municipality continues to experience spontaneous disruptive protest as a result of erratic water and electricity supply. The debt owed to the Department of Water and Sanitation amount to $500 million, and there's a non-compliance to green drop water services and ESCOM historic debt of $2.6 billion. Now we are dealing with recommendations, members. Having conducted proactive oversight visits and interacted with internal and external stakeholders of the local municipality, the Select Committee recommends to the NCOP follows. In line with the executive decision undertaken by the Deputy Minister of COGTA, SALGA and the Free State Department of COGTA should jointly provide and continue to support in terms of Section 154 of the Constitution to the local municipality. The joint support, meaning of the Deputy Minister of Cocta, MEC of Cocta and Salga, should focus but not limited to support and strengthen the capacity of local municipality in executing its legislative work, ensure functional and resource impact, filling of critical vacant positions, implementation of performance management systems, development and implementation of financial recovery plan, municipal audit action plan, local economic development strategy, and service delivery, as well as budget implementation plan. 10.1.3, the local municipality should fast track the process of engaging the Department of Land Reform and Rural Development, as well as HDA for land donation or purchase for smart city plan. The local municipality should also fast track the process of tabling the local economic development strategy to the Council for adoption and implementation. 10.1.4, as part of improving municipal organizational development and transformation, the acting municipal manager should implement the resolution of local labor forum in line with the approved municipal organizational structure, competency requirements, and grading system, as well as fast track the process of filling critical vacant positions of the Director of Human Settlement, Special Planning and Development. 10.1.5, the local municipality should develop timeframes and fast track the process of handing out of 300 title deeds in Kwakwa and reviewal of farmlands contracts. 10.1.6, as part of dealing with electricity crisis and ESCOM historic debt of 6.6 billion, the Free State Department of Cocta should fast track the process of submitting the proposal of ESCOM partnership agreement model to the National Treasury for consideration. 10.1.7, the Free State MEC Cocta should table the notice of intervention in a local municipality in terms of Section 139, subsection 5 of the Constitution to the NCOP. This recommendation, honorable members, is based on the fact that in terms of the constitutional requirement, the Free State Department hasn't tabled this notice to the NCOP so that it can be referred to the committee for consideration and reporting. 10.1.8, the Free State MEC Cocta should investigate allegations of corruption and stealing of municipal properties by the officials and table the report with the findings to the NCOP and the provincial legislature, meaning the Free State provincial legislature. 10.1.9, the Free State MEC Cocta should notify the NCOP and Free State provincial legislature about the invocation of Section 139, subsection 5 of the Constitution and in the local municipality, and provide quarterly reports on the implementation of the intervention. The last one, honorable members, the Free State Department of Cocta should, upon the adoption of this report by the NCOP, ensure that the local municipality shares the report with the internal and external stakeholders of the local municipality. Chairperson, thank you very much. This is the observation and the recommendation.
Thank you very much, Moss. This was a very clear report, and I'm quite happy in the manner that you presented it. To just make this, to underline this point, in future you present all the reports of the committee in the manner that you have presented. It's no longer going to be me who's doing that. Honorable members, that is a report before us. I'm sure Moss has noted some typographical mistakes, some alignments and editing. Please attend to that. I picked up some few of those. Be that as it may, the report is before the committee. Any suggestions, contributions, discussions? If there are none, let's consider to adopt the report. Over to you, honorable members. I know the hand of Honorable Sileku, Honorable Sheikh, Honorable Fesser. Yeah, in that order.
Good morning, Honorable T.S. Dodov, honorable members, and to the officials. Chair, thank you very much for the report. I was part of that oversight, but one concern that I have, Chair, I just wanted to know whether some of the recommendations are still valid or not, because it's been, I can't even remember when we went to that particular oversight visit. And one would just want to know in terms of the recommendations that we are.
It was in August, Honorable Silegu. I think the 16th of August we were there. Yeah, 16th of August.
Yeah, I'm just worried here. Like, for instance, if you say there's an acting MM there and there is no longer an acting MM, then which means the recommendation is directed to someone else. So I would just want to know whether some of the recommendations are really, really valid since it's been more than 3 months now since we had that oversight. Just that question, Chair. Thanks.
Thank you, Honorable Sheikh.
Thank you very much, Chairperson. I want to agree with you that I think the report was very clear, and I think it did cover all aspects of what was discussed in that in our engagement. I just want to verify whether perhaps as a committee we should at a later stage also revisit Maluti Apofung, especially in terms of all the support initiatives that are required by the provincial and the national department to that municipality. Well, I don't want to respond to Honorable Seleku, but I think our recommendations are our recommendations, and I think perhaps they relate to at the time of our engagement. And perhaps it's something that when we review our recommendations, obviously we would look at progress on the various recommendations. And I'm sure that the issues that Honorable Seleku raises as well will also be clarified in that process. Thank you very much.
Thank you very much.
I would, yeah, okay.
Okay, thank you very much, Honorable Sheikh. Honorable Professor.
Thank you, Chair. I hope I'm audible. I've got a very bad voice. I wasn't at these, it was the time my husband had an operation. I wasn't there, but I'm shocked to see the regression that has happened there. I just want to know what about consequence management and keeping people accountable? The acting MM, those people in the administration, apart from the council, people in the administration must be must be held accountable for the mismanagement, for the theft, for things like that. Shouldn't there be somewhere in the report also that action must be taken and that there must be accountability must be one of the primary aspects to focus on in each department, and consequences must happen to those that are guilty of support. Thank you.
All right, thank you, Honorable Professor. Honorable Mtatwa.
No, thank you very much, Chair. Mine is that since this report is
Honorable
I must say that and it's one of the good report. Yes, Chair.
Oh, no, you're okay now.
Video, Chair. I'm okay now.
You can speak now, but we heard what you said, but your voice was terrible.
Oh, okay. Okay.
Yes.
No, sorry for that, Chair. I was saying that now that many of these issues that has been highlighted in the report, I just want to second those that says, Chair, a report like this need a follow-up. If we can just edit in our report that the NCOP would love to do a follow-up on this matter so that we see how are they going to turn around the corner, because almost on a daily basis, things are not getting to the right direction under that municipality. I just want to check with you, Chair, that how possible it is that it can be there rescheduled to go back and check, maybe after 2 months, go back to this municipality and ensure that the things are moving in a right direction. Maybe this will also going to cater even the issue of disciplinary actions to see how far are they going with those matters, because we particularly yourself, Chair, you have raised very harshly on these matters of corruption into this municipality.
Yes. No, I agree with all what that you are saying, honorable members. Firstly, to Honorable Sileku, I think the report will need to be updated because it has been 3 months since we went there. But how to do it is exactly what Honorable Sheikh said, that it will be through progress reports that we receive from the municipality. And one of the recommendations is that once we have adopted this report as a house, we need to get the status quo report from the MEC of COGTA, so that we check whether there is progress, all issues raised were followed up or not, and there are any improvements in that municipality. I agree. I also agree that we need to follow up this municipality. This is one, as we are aware, one of the most unstable municipalities in the country. But to just remind honorable members, the municipality, as we speak now, is under the coalition government. After the previous government, which was there before the elections of November 2021, was ousted. And it would seem that the problems are not improving, but they are escalating. We have more problems than in the past, and this is a concern that we raised when we were there. And I wholly agree that because this municipality has been on our radar. Last year it was for the second time in 5 years, something that is doesn't happen easily, that we visited that municipality. I think, yes, we need to do that. I think this would be our flagship municipality, that we follow up, that we ensure that whatever that is wrong is corrected. I agree with that. With regard to what Honorable Fisher was saying in terms of dealing with the problems that are obtained in that municipality, especially related to corruption. If you can see one of the recommendations, I think it is recommendation 6 and 7 of this report. They speak to the fact that we need to get an updated report, and issues of corruption and the stealing of municipal properties, especially by the official, need to be dealt with accordingly. And as part of our recommendations, we are saying the MEC must put up the necessary measures, the necessary systems and structures to deal with those issues related to corruption. And I think this is one question that we must ask the MEC of COGTA in the Free State. How have you dealt with all the issues and the recommendations of the NCOP, including the issues of corruption and the stealing of public properties? And when we were there, it was quite clear in terms of the report that we received that there was a pattern of, and this was very, very big, the theft that was happening to the properties of the municipality. And this is an issue that I think we must follow up. With that said, I see some hands. Are these the legacy hands or are these the new hands? Honorable Fisher, Honorable Mted, or yes, Honorable Mted is out. Honorable Fisher, are you doing a follow-up? or is a legacy hand?
The old hand.
Honorable Sileku?
Chair.
Yes, Honorable Sileku.
Okay, I don't know how to put this one, but I think it's a very sour issue for my side since I've been part of this particular committee for the last 3 years. And I'm linking it to the comment that was made by the DM, which I appreciate when she was part of our delegation in MAP. You know, what the comment was like, maybe, COGTA did not apply their mind when they concurred or when they revoked Section 139. And it also latches to what Honorable Fisher is saying, that we find ourselves in most instances as the members of the NCOP, agreeing on decision that has been taken by another sphere of government, but we don't see any progress. What we see is mostly regression. Maybe, Chair, I don't know, maybe one time or in the near future, that the different spheres of government must try to sit and engage on the issues of Section 139's, application, so that we do justice. Because currently we are not doing justice, and we revoke, and we get the regressions over and over again. And then our committee, I cannot remember any decision that we have taken in the last 3 years that we have saved the municipality, but all we have done is just to concur with the other spheres of government, and also, supported regression, and which I feel is an injustice, in terms of what we must do as members of parliament. Thank you very much, Chair.
Yes, I hear you, Honorable Sileku. But if you remember quite well, it is our job to confront all the spheres of government. If they are not doing their job, it is our task to expose that and insist that they must do their job. But at the same time, I think we need to be specific which areas that we are not satisfied about, and which areas that we need improvement, and we must call them. We must call them to account. And I think through this report, this is what we are trying to do. And maybe let's go to the House, present the report, let it be adopted, and let it serve as a framework for us to enforce oversight and accountability from those who are involved, to ensure that at the end of the day we succeed. But my view is that we need to be quite specific and say, on this area and that area, on that area, there is regression. We are not happy about it, and we think that it needs to be done. And what are the consequence measures that we're putting in place, that we insist that this must happen if they have not happened. It is our task. But for now, I think let us agree with the recommendations submitted. Let us receive the necessary update reports from the MEC. Let us discuss and engage with them. Let us ask them tough questions in respect of enforcing our recommendations that they must be implemented. Let us express our views if we are not happy about their performance, about the implementation of Section 139, whether it is 1B or it is 1.5 in this case. Let us do that, and nobody must stop us. Nobody is stopping us from doing our job to exercise oversight and to insist that things must be done and they must be implemented as per our recommendation. But for now, I think let us move forward in line with what is recommended here. Any mover for the adoption? Or otherwise? Honorable Sheikh?
Yeah, Chairperson, I move for the adoption of the report with the inclusion that we go and revisit the municipality at a suitable time. Thank you, Chair.
Yes. All right, thank you very much. Any seconder? Honorable Mthatwa.
Yes, Chair, I moved, I second the move of adoption of the report. Thank you.
Okay, thank you very much. Any opposition to the adoption of this report?
None, Chair.
I was saying that, I muted myself, I'm sorry. I was saying that in the absence of no opposition to the report, in the absence of no objection or abstention to the report, I say that the report is unanimously adopted by this committee. Thank you very much for that, honorable members. Let's move to the second report, the report on our visit to Mpumalanga, specifically to interrogate the reports, the investigations report in respect of section 106 of the Municipal Systems Act. Over to you again, Moss. Do the same. Take us through the observations.
Thank you very much.
Yes.
Thank you very much, Chairperson. Ms. Holiday, the observation and recommendation start at section 14. Thank you. Honorable members, I need to make a declaration that this report is the first time that I write section 106 forensic investigation report. I've tried to be creative here to link observation and recommendation per structure, Chairperson. With your permission, Chairperson, we're starting.
That is what you must do. If there are observations per municipality,
yes, Chair.
Unfortunately, this is what we must do. If there's recommendations per municipality, that is what we must do.
Sure, Chair.
For the purpose of this meeting, for our record, if you have done so. But if you have lumped them together, it's okay. You can present them in that fashion. But in future, it must be observations per municipality, recommendations per municipality.
Chairperson, with your permission, I've done exactly that with your first, observation to say observation and recommendation per municipality. This report has been structured in line with what you said, Chair. One, we are starting with the Department of COGTA. 14.1, the Select Committee has noted that the Department of COGTA has conducted investigations in terms of Section 106, Subsection 1 and B of Local Government Municipal System Act of 2000 in Lekwa Local Municipality on July 2018, Dr. J.S. Boroka Local Municipality in March 2020, Dr. Prislika Isaka Seme Local Municipality in June 2020, Gabonbeki Local Municipality, June 2020, Dipaliseng Local Municipality, September 2021, Nkomasi Local Municipality, October 2021, Emalahleni Local Municipality, November 2021. 14.2, the Select Committee has noted that the Department of COGTA handed over reports and findings to local municipalities in order for the municipalities to develop action plans and implement findings and recommendations. 14.3, the Department of COGTA handed over forensic investigation reports to Lekwa Local Municipality on the 8th July 2020, Dr. J.S. Moroka and Dr. Presika Isaka Seme Local Municipality, Gabonbeki, on 6 October 2022, and the Padise Local Municipality on 10 February 2022. All these local municipalities submitted their action plans that were approved by their respective councils and submitted to the Department of COGTA. 14.4, the Select Committee has noted that after the local government elections, the Section 106 forensic investigation reports were resubmitted by the Department of COGTA to the new municipal councils with a directive that they must be retabled to the new councils. 14.4, SC COGTA has noted that the reports for Section 106 investigations in Nkomazi and Emalahleni local municipality have not yet been handed over to the respective municipalities by the Department of COGTA. 14.5, the Select Committee has further noted that Section 106 forensic investigations in Bushbuck Ridge local municipality has not been finalized by the Department of COGTA due to lack of cooperation from the local municipality. The investigation has been restarted on 5th October 2022. Based on the assessment report tabled by Department of COGTA, the Select Committee has noted with great concerns the slowness of local municipalities in implementing the recommendation of Section 106 Forensic Investigation Report. Of great concerns also by the Select Committee and the Department of COGTA is the slowness of Dr. J.S. Moroka local municipality in implementing Section 106 Investigation Report. 14.7, in order to oversee the work done by local municipalities in implementing recommendation of Section 106, the Select Committee has noted that the Department of Court has established a project steering committee composed of Provincial Treasury, South African Police Services, the National Department of COGTA, go down message. Next page, please. 14.6, in light of the above observation, the Select Committee on COGTA recommends as follows. Mpumalanga Department of COGTA should fast-track the process of handing over the reports for Section 106 investigation in Nkomazi and Emalahleni local municipality. 14.6.2, the mayors of Nkomazi and Emalahleni local municipalities should ensure that the municipal managers develop municipal action plans to deal with the findings and recommendations emanating from the forensic investigations conducted in terms of Section 106 of the Local Government Municipal System Act. 14.6.3, Mpumalanga Department of COGTA should monitor the progress made by above-mentioned local municipalities in developing municipal action plan on Section 106 findings and recommendation. 14.6.4, MEC of COGTA should table reports on each local municipalities on the outcomes of forensic investigations conducted in terms of Section 106. Now, this one, Chair, we are done with observation and recommendation for the department. We are now focusing on observation and recommendation for the National Prosecuting Authority. 15.1, the Select Committee has noted that most of fraud and corruption cases that the MPA is dealing with need unique skills from both the investigators and the prosecutors. The cases of MPA is dealing with take a long time to investigate due to their complicity, such as forensic audit reports. 15.2, the Select Committee has also noted with great concern the institutional weakness and under-resourced challenges experienced by MPA in performing its mandate of processing criminal cases. 15.3, these institutional and witness challenges include the service by one dedicated specialized commercial crime court and reluctance of witnesses who are in the employment of the municipalities to cooperate due to fear of reprisal. 15.4, the Select Committee has noted with serious concern that when complicit municipal officials become aware of investigation, they begin to hide or destroy documents. 15.5, the Select Committee has further noted with great concern that the witnesses who do cooperate with MPA end up being victims of occupational detriment, such as suspensions and disciplinary actions, as well as assassinations. 15.6, the Select Committee has furthermore noted that the DPCI in Mpumalanga is under-resourced. Only one investigator carrying many dockets, resulting in workload. In terms of statistics, the Select Committee has noted that there are 10 numbers of court cases, 10 numbers pending decisions by MPA, 20 number of cases under investigation, 40 number of cases on hand, and 70 cases of Section 106 investigation reports. 15.7, the Select Committee has noted with concerns investigation matters that affect all the 3 law enforcement agencies, meaning the MPA, HOGS, and SIU and SEIU. The general concern raised by members of the Select Committee relate to age-delayed cases, recycling of officials implicated in corruption cases, killing of key witnesses in corruption cases, lack of arrest and prosecution of people involved in corruption, referral of cases back to investigators, inadequate courts and magistrates to deal with corruption-related cases. 15.8, the Select Committee has also noted with serious concern about unresolved related corruption cases, delays in opening corruption case numbers, reluctance of whistleblowers to participate in protection program, lack of consequence management, gaps in implementation of coordination and anti-corruption strategies, slow implementation of Section 106 findings and recommendations, destruction of documents by municipal officials implicated in fraud and corruption allegation cases, and failure to recoup monies misappropriated as a result of fraud and corruption in municipalities. In light of all the above observation, honorable members, the Select Committee recommends as follows, specifically to MPA. MPA in Mpumalanga should fast-track the process of recruitment, selection, appointment of investigators in order to deal effectively and efficiently and generally with allegation of corruption, fraud, and specifically in local municipalities. 15.7.2, MPA in Mpumalanga should strengthen collaborative work with other law enforcement agencies, such as Special Investigation Unit and Directorate for Priority Crime Investigation Unit, in order to effectively and efficiently deal with allegations of fraud, corruption in local municipalities. Now, honorable members, we are dealing with observation and recommendations specifically to the HOGS. 16.1, the Select Committee has noted that the HOGS in Mpumalanga is currently investigating cases of fraud, corruption in Bombela local municipality, the Palisane local municipality, Nkomazi, Steve Swete, Gabonbeki, Amalahleni, Dr. J.S. Moroka, Dr. Prisika Isaka Seme local, Bushbuck Ridge, Lekwa, Tabatweu, and Sukalikwa local municipalities. In line with the progress report tabled by the Department of Cocta, the Select Committee has noted that the HOGS is currently investigating matters related to corruption in all those municipalities, but there is no prosecution yet. 16.3, although progress has been registered in terms of opening criminal cases, provision of case numbers, description of case fraud and corruption, Select Committee has noted with concerns the absence of arrest, slowness of prosecution of people involved in corruption, fraud, maladministration in local municipalities. 16.4, the Select Committee has noted that DPCI is experiencing capacity challenges and the Directorate is in the process of advertising the post. Besides the capacity challenges, the Select Committee has also noted other challenges faced by the HOGS in executing its mandate and delaying investigation. These include incomplete information provided by the municipality and the vastness of the policing area due to geographical structure of Mpumalanga provinces. In light of the above observation, the committee recommends as follows to the HOGS or DPCI that they should fast-track the process of recruitment, selection, appointment, is the same as the one that we're dealing with the MPA, in order that they can perform their functions and deal with matters related to allegation of corruption and fraud. 16.6.2, DPCI should strengthen collaborative work. Is the same, Chair. This is an emphasis that the members were raising serious concern that it seems to be a disjuncture with regard to their operation. Now, the last one, Chair, this one deals with SIU. The Select Committee has noted that SIU has received various allegations of irregularities, corruption, wasteful expenditure from the whistleblowers and the media relating to Mbombela, Mkondo, Dr. J.S. Moroka, the policy and Tabal. So this is an emphasis that in terms of record, these are the allegations that they received. 17.2, the Select Committee has noted that SIU Business Development Management Team has started an engagement session with municipal managers and speakers respectively to request documents relating to allegation of irregularities, corruption, wasteful expenditure from local municipalities in order to start the internal process. The Select Committee has further noted that the information documents received from Mbombela local municipality and Mkondo have already gone through the internal process of the Special Investigating Unit. Furthermore, the Select Committee has noted that the Case Assessment Committee of the Special Investigating Unit has recommended motivation for proclamation to be forwarded to the President of the Republic of South Africa via the Department of Justice and Correctional Services, so that signed proclamation by the President could authorize investigation in Mbombela municipality and Umkhondo local municipality. In light of the above observation, the committee recommends as follows. The Case Assessment Committee of the Special Investigation Unit should fast-track the process of determination of the allegation of fraud, corruption, wasteful expenditure in Dr. J.S. Moroka, Dipalisen, Tabatso, Victor Kanye local municipality, like it has done within Mbombela and Umkhondo local municipality. Just an emphasis of consistency, honorable members, that committee should also speed up that process. 17.5.2, the Special Investigating Unit should strengthen collaborative work with other law enforcement agencies. This was, we are trying to ensure consistency. We've made this kind of recommendation that there should be collaborative work and alignment of programs within this law enforcement agency. Next page, Holiday. Observation and recommendation. Now, Chair, as we indicated, now we are dealing with observation and recommendations per municipality now. Number one was stated Dr. Priscilla Isaka Sema local municipality. The Select Committee has noted that in terms of assessment report tabled by Department of Cocta, the local municipality has made progress in addressing 6 findings of Section 106 report, and that a number of short-term recommendations have been addressed. 18.2, the Select Committee has noted that in terms of assessment report tabled by the department, the local municipality has instituted consequence management against officials currently in the employment of municipality who have been implicated in wrongdoing. 18.3, the Select Committee has further noted that the municipal manager and the manager of performance management unit have been suspended and are undergoing disciplinary posts. 18.4, while acknowledging the process made, the Select Committee has noted with great concerns that in terms of assessment report tabled by the department, the local municipality has not taken action against former employees and councillors who have left the municipality but were implicated in allegation of wrongdoing. In light of the above observations, the Select Committee recommends as follows. Dr. Priscilla Isaka Sema local municipality should institute civil case against officials and councillors who have been implicated in fraud and corruption in the local municipality, including the recouping of monies misappropriated. The local municipality should fast-track the process of disciplinary hearing of the municipal manager of performance management unit that have been suspended and are undergoing disciplinary processes. The local municipality should provide quarterly reports to the Mpumalanga Department of Cocta on the implementation of the above recommendation, meaning the recommendation of the committee. This one, 19, this one, Chair, we're dealing with observation and recommendation for government-based local municipality. Now here we are saying the select committee has noted that the local municipality has resolved some of the recommendation. It has fully resolved some of the findings and the rest are still work in progress. The municipality has initiated disciplinary processes against implicated officials. However, none of the officials have been found guilty. The select committee welcomed the initiative of the local municipality in reporting cases of fraud, corruption to the Hawks, and this has been investigated. The select committee has noted and welcomed the commitment of the Department of COGTA to monitor the local municipality in implementing Section 106 report. In light of the above observation, the select committee recommends as follows. Government-based local municipality should fast-track the process of resolving all outstanding findings and recommendations of Section 106 investigation, as well as disciplinary processes against officials implicated in corruption, in fraud and corruption in the municipality. The local municipality should provide quarterly reports to Mpumalanga Department of COGTA on the implementation on their action plan. Observation dealing with LEQUA and recommendation. The select committee has noted that the municipality has made progress in addressing finding of Section 106. However, in terms of the assessment report by the Department of COGTA, the municipal progress has been very slow. 20.2, the select committee has further noted that the municipality has managed to fully resolve 5 of the findings of Section 106 report. However, the select committee has noted with serious concerns about lack of consequence management for both officials and business entities implicated in wrongdoings in a local municipality. 20.3, the select committee has further noted with serious concerns that there have been no civil cases instituted against officials and business entities implicated in wrongdoings in the local municipality. In terms of the assessment report tabled by the Department of COGTA, the select committee has noted that the local municipality has indicated some of the matters have been referred to the law enforcement agency for further actioning. However, there's no report that has been provided. In light of the above observation, this is a recommendation of the committee. Local municipalities should institute civil case against officials and councillors who have been implicated in fraud and corruption in local municipality, including the recouping of the money misappropriated. The local municipality should provide quarterly report to the Department of COGTA on the implementation. The local municipality should also provide quarterly report. I beg your pardon, honorable members. Let me reread 20.5.2. Local municipalities should provide report on matters that have been referred to the law enforcement agency for further actioning to the Department of Cooperative Governance and Traditional Affairs. 20.5.3, local municipalities should provide quarterly reports to the Department of COGTA on the implementation of the above recommendation. Correct. We are now, honorable members, dealing with observation and recommendation for Dr. J.S. Moroka local municipality. The select committee has noted with serious concern that the local municipality has achieved minimal progress in addressing the findings and implementing the recommendation of Section 106. In terms of the assessment report tabled by COGTA, the select committee also noted with concern that the only progress reported by local municipality is that the matter has been reported to SAPS, Directorate for Priority Crime Investigation, but there are no case numbers provided by the local municipality. 20.3, the select committee has further noted with serious concern that in terms of the assessment report, the local municipality has dismally failed to implement consequence management against officials and councillors implicated in wrongdoing, and also failed to recoup the municipal funds or monies wrongly used. In light of the above observation, the committee recommends as follows. Dr. J.S. Moroka should implement consequence management institute civil action against officials and councillors who have been implicated in fraud, corruption in local municipalities, including recouping the money that was wrongly used. 20.4.2, the local municipalities should provide case numbers of the fraud and corruption to the Directorate of Priority Crime Investigation and the Department of Cogta, and the Department of Cogta should, honorable members, with your permission, this paragraph will have to be reconstructed. It does not make sense how it has been captured. Dr. J.S. Moroka should provide case numbers of fraud and corruption to Mr. Olidi. Can you just go up so that we can just correct this paragraph, please? Yes, thank you. 21.4.1, Dr. J.S. Moroka local municipality should implement consequence management and institute action against officials and councillors who have been implicated in fraud and corruption in local municipality, including the recouping of money. 21.4.2, the local municipality should provide case numbers of fraud and corruption to the Directorate for Priority Crime Investigation and the Department of Culture in order to enable action by the law enforcement agencies. With your permission, all the members will correct this paragraph just to read properly. That should be removed on our members. 20.4.3, the local municipality should provide quarterly reports to the Department of Culture on the implementation of above mentioned recommendations. This one, all the members, deals with the Ipilise local municipality. Here, the committee noted that in terms of the assessment report by Cogta, this municipality has established an ad hoc committee of council, which includes chairperson of audit committee, to monitor the implementation of the action plan on Section 106 forensic investigation. 22.2, the select committee has further noted and welcomed the significant progress of the municipality in addressing the findings of Section 106. Furthermore, the select committee has also noted that in terms of the assessment report, the local municipality reported cases of maladministration, fraud, impropriety to the law enforcement agency, that the municipality has provided the case numbers as compared to other municipalities that could not provide evidence of the case numbers. 22.4, while welcoming the municipal action of instituting disciplinary process against the implicated officials, the select committee has noted that in terms of the assessment report, the local municipality has not instituted civil case against officials who left the employment of the municipality and the service providers who are implicated in wrongdoing, including the recouping of money. In light of the above recommendation, the committee recommends as follows: that the municipality should institute civil action against officials and service providers who have been implicated in fraud, corruption in the local municipality, including recouping the money of the state. 24.5.2, the local municipality should fast track the process of disciplinary hearing of the officials who are implicated in fraud, corruption in local municipality. The last one, the local municipality should provide quarterly reports to Mpumalanga Department of Cogta on the implementation of this recommendation. Here, honorable members, just to make a short comment, members will recall that chairperson made a commitment that within 3 months, we'll have to have another meeting so that we make an assessment of the progress made by these municipalities and law enforcement agencies. Now, in order to ensure consistency, we are saying each and every municipality implicated with regard to Section 106 forensic investigation, they must provide quarterly reports to the Department of Cogta, so that when members engage with the department and law enforcement agency, there could be portfolio of evidence from the municipality and the department of the progress made by the municipality. The last one, Chair, it deals with observation and recommendation with our interaction with the Portfolio Committee on Cogta in Mpumalanga. The Select Committee has noted and welcomed the commitment made by the chairperson of the Portfolio Committee on Proctor to strengthen oversight in order to ensure executive and municipal accountability on the implementation of action plans related to findings and recommendations emanating from forensic investigations conducted in terms of Section 106 of Local Government Municipal System Act. In light of the above observation, the committee recommends as follows. The Select Committee and the Portfolio Committee to jointly coordinate during the first term of 2023 parliamentary period in order to schedule a follow-up oversight meeting with the Department of Proctor, Law Enforcement Agency, MPA, ROCS, SIU, and affected municipalities on the implementation of action plan, status of investigation, cases, prosecutions in terms of Section 106 forensic investigation, in terms of Section 106 of forensic investigation in their local municipalities. Chairperson, thank you very much. It was an opportunity and honor to present the report.
Thank you very much, Moss, for the report as well. Without further ado, let me invite comments and discussions from members of the committee. I'll later make some suggestions on the report itself, having listened to members of the committee. Over to you, members. No hand? Are you satisfied with the report? Oh, Honorable Silegu, followed by Honorable Sheikh.
Good afternoon, Chair. Before Sheikh, let me start. Chair, firstly, let me appreciate the work that has been put into the report. And there is just a few things that one is of concern of, Chair, and I don't know how one can actually deal with in this particular report, especially when it comes to some of the recommendations from the Section 106 reports. Because some of the recommendations that one would be given by the presenters there would say that you should actually deal with this matter in such a way, and we as the members of the committee would feel that that recommendation actually is not. It's very light. For example, for the cashier, that the recommendation for the cashier was that the cashier must be given enough training because she did not qualify, or he or she did not qualify for that particular position. So such recommendations makes one wonder how one should deal with it. And that is one concern, Chair. And secondly, Chair, is that the timeframes of tabling of these particular reports, and I think we had several discussions offline in particular about this Section 106. Firstly, there's a problem in terms of 106 because 106 does not specify by when an investigation must be concluded and by when a report must be, handed over to a council, and by when a council must actually, table the report, and by when recommendations of this nature should be dealt with. So when all of those things, Chair, leaves room for people to dictate, to delay processes. And I was actually wondering, how are we going to make sure that, for a particular recommendation that says you must deal with this member of council via disciplinary process. And then what happens? A report is tabled when that member is no longer part of that council. And then they will say case closed. Then it becomes an argument between me and it became us as members of parliament and presenters, saying like we don't agree, and all those kind of things. So I don't think that's a nice way of dealing with consequent management. And one, maybe what we as a committee should actually try to have a discussion in terms of this particular, 106, and see how it can actually complement us as members of parliament in terms of doing our oversight role, And also, Chair, the other thing of, unfortunately, when it comes to the law enforcement agencies like the Hawks, every year we hear that there is no resources, there is no capacity, they are underfunded. But unfortunately, whenever we deal with appropriation and we deal with the budgets of these particular ministries, I don't hear us, I don't hear any of us, advocating for the Hawks or for these law enforcement agencies to be given more, money, or to be given more, capacity. So at the end of the day, now I also get sometimes confused. We as members of the NCOP, when we deal with bills, we, with the revenue or bill, and then we would agree knowingly that it is not going to assist, these law enforcement agencies. So it's no use for us, Chair, to put recommendation that says that capacity must be given to this institution when we are members of the NCOP. When we have to deliberate on whether we agree on the budget or not, we would agree knowingly that they are not going to do something. So it's becoming like, it's almost like we are not serious about what we are doing, because we agree on something that we know is not going to assist us, and it's not going to assist the law enforcement agencies. And then when we deal with them, we tell them, now you don't have capacity, you need to get more capacity. So, hypocrisy, it creeps in sometimes. We don't put our interest of our provinces at heart. We follow our organizations and we agree on things knowingly that we're not going to achieve anything. That's just my observations and comments. Thank you very much.
Thank you very much, Honorable Sileku. Honorable Sheikh.
Thank you.
Faisal, followed by Honorable Mtatu.
Thank you very much, Chairperson. I just thought perhaps, I think we should really appreciate this report, Chairperson. Firstly, I think that it was very well structured, and I think it also contained all the relevant issues as discussed by the committee. And I think the drafters of the report, I think Chair should be also commended on this report, Chair. Chairperson, I just wanted to make one more addition. Given that, we're looking at section 106 investigations, I think that we should perhaps also try and strengthen, our partnership or engagement with the relevant portfolio committees in the legislatures, because I think that will also assist with reference to oversight follow-up on the various matters that are also being raised in our various recommendations as well. Thank you very much.
No, thanks, Chair. Mine is the issue of this. First, let me also recommend that the report was a very high-level report. But there were simple cases, Chair, which I can call it very low-hanging cases, low-hanging fruits. And those cases, Chair, in that province, we've noticed that nothing is done on those matters. Even is the case of people just transferred money from one account to another county. Besides those two municipalities that we did not, the other four, like Yotlanzen, we did not do anything there. Did not get those reports, still not yet done anything. But we don't get any case that has been finalized in that province. The issue of safety and security in that region is very worrisome, Chair. I think it's another area that needs visiting again. make sure that if things are really happening there, or we just assign the department to ensure that they give us a report almost every 2 months of the progress of the area. Thanks, Chair.
Thank you very much. Honorable Officer, you raise your hand.
Thank you, Chair. And I cannot agree more that I want to extend also my thanks and appreciation for a report well done. Chair, listening to these reports today, I am even more concerned about the position of accounting officers in a municipality. We cannot allow, as Honourable Ntekwa also now said, about the things that is happening, it's like blatant theft, looting, with the intention to take away everything from that municipality. That is why people do not have water and when there's no services. So what about the Act on the Prevention of Fraud and Corrupt Activities? It's something that can be used very well because everybody in the line of that will be held accountable should anything happen in that department or whatever, and they knew about it and they didn't alarm the accounting officer then if he is also not involved. But it is alarming if I take it from the last 3 years when we visit municipalities that the fraud and corruption has increased dramatically. And it's something we have to do something about because we cannot allow this to continue and people sitting without water and without essential services and accounts of ESCOM and all these things are just getting up higher and higher and higher and everything's becoming a big problem for us. Thank you, Chair. That's all. That's my contribution. Thanks.
Thank you very much, Honorable Professor. Honorable members, firstly, remember that it was for the first time in 3 years that we undertook a targeted oversight visit to Mpumalanga. And remember that we identified one of the key sections that centers around our work, that is Section 106 investigations. And as you know, Section 106 of the Municipal Systems Act empowers the MEC of a province to undertake and to appoint an administrator to investigate allegations of corruption, fraud, and malfeasances. And now all of these reports across the country are piling. Even if we can ask a question to all the MECs, tell us all your investigation in terms of Section 106. Which municipalities you investigated? Did you receive all the forensic investigations report from the municipalities? When did you receive them? What did you do to implement the recommendations contained in the forensic investigations? Are there consequence management? Are those responsible for these things held accountable? Were they criminally charged? Were they suspended? Was disciplinary actions taken against them? All of these questions, dololo, or you'll get inconsistencies in terms of the responses. And just Mpumalanga, going to Mpumalanga, for me, there are a lot of lessons that we can draw from that visit. Quite clearly, they don't take 106 serious. Quite clearly, they don't investigate as they should. Quite clearly, the investigations take a long time. There are a lot of delays. Quite clearly, they don't collaborate and work with law enforcement agencies. Law enforcement agencies, even in terms of this report that is before you, points that they are not doing as much as they should. Cases are delayed. Witnesses are reluctant to submit statements, or they vanish, or some of them are assassinated. All of these things. And for me, this is a key lesson for us as a committee going forward, how we are going to do our work. I thought perhaps I must just raise this point as a general point, but the report is before us. The report points out a number of lessons that you can draw from this. And as you can see, the recommendations, as you can see, the observations, they tell you that this thing of Section 106 interventions, people are not taking them serious, and it's a problem, and we need to do something about it. My observation is that the report is good. The report highlights where the weaknesses are. The reports give us clear-cut recommendations about what needs to be done. Firstly, I agree with Honorable Sileku that as an overarching point, we must recommend to the House that we need to drive the process to amend Section 106 of the Municipal Systems Act. There must be the amendment to this so that we tighten up the screws. And those amendments must pertain to when these investigations should take place, when should they be finalized, and how these people must report to the NCOP, and when, and what do we do with all the recommendations. Generally, for me, I think Section 106 needs that, because if we don't enforce this legislation, is there anyone want to speak?
Yes, my hand was up.
No, I didn't see your hand, Honorable Motsamai. Let me just finish this. I'll afford you that opportunity. I was saying that quite clearly with this, there are problems. A report either is submitted or is not submitted at all. A report takes 5 years to finalize. And that is why people leave the service of a municipality, and now there's a confusion. What do you do with those people who have left? For me, we need to tighten up the Section 106 amendments. That provision needs to be amended so that it caters for this lacuna that you see in the Act. I didn't see Honorable Mozamai. Let me give him the opportunity, and I'll proceed with regard to what I wanted to say. Honorable Mozamai.
Thank you, Chairperson. Ke rata o mmamele hantle, Chairperson. Ke bona ekare go mo Mpumalanga mole Section 106 ha bana taba le yona. Ntho e teng go na le matshosetsi a di whistleblower, go be go ba gape le matshosetsi a di weakness. Ga o shebile issue ya JS Moroka, go re la ntlha ke rata fela gore report e fetswang go bua ke secretary ya rona ke nkela haholo hlogong, ene o buile ntho e le gore ya tshwareha. Mara ga o shebile corruption e etsagalang mo le matshosetsi mo e leng gore mongwe le mongwe e leng gore o involve mo corruptioneng o tshwanetse gore a ska appear before the court. How to shebella the works or the special investigating unit e ka re se a tshaba, e ka re go na le batho ba ile gore ba tshabiwa gone mo Mbombela le mo Makhado le yone JS Moroka. Engwe e tshosang gore o tlo re go le mo temo o re o mametse bopaki be ba o bolela gore go na le batho ba ileng gore they were member of them, they are in parliament. Mara ga o re wa e latela o bo thola gore there's nothing, there was no one who was charged. They didn't even say motho ona na sa tshwanna gore ka ba le parliament because o na le case le rona. Mara no yana gantse e tsweletse o tlo bona gore no, Chairperson, go mona e ka re go na le go sebedisa go zondana go tlhoana ba sa sebedise toka ga e se yo mo and the case tse leng gore re di shebile tse leng gore ne respectile gore no yana re ke be re bona bontsi ba batho ba ile gore ba jele tšhelete ya setšhaba ba appeara before the court or ba ditšhankaneng ke be ne re ba bona ile gore ba goga boima ba palelwa go tsama ba rwele ditlhako tse di sa ba lekaneng go ditšhankaneng mara they are still outside a gona anything e tsagalang the hawks di a ba tshaba. Then you ask yourself, for Arenalo and Maponisa at investigate and but Baba Chuleta corruption. Because these people both fetted the limo, be baswe, the case of one simple. Kialoboha Cheperson. I only little Kaitsa one, Kamu, Rotole report a matter, eight or more, which were young about Baylor. They've committed a crime and a crime agabai and say corruption especially. Or which were young about Kialobo.
Yeah, thank you, Honorable Amai. Those are some of the issues that we're picking up in respect of this report. I was going to make an overarching proposal about what we need to do in respect to the whole report. But first, I propose that we need to encapsulate a recommendation that calls for the review of the Section 106 of the Municipal Systems Act. But two is that a lot of issues are hanging. The reports of other municipalities are not finalized. The reports of the Hawks, of the NPA, of the SIU are not yet finalized. They are still doing their work. I think there is a case that we must call them again. We must give them the priority and call them again to Parliament. Compare what they have said to us as containing this report and progress that they would have registered, and whether all these recommendations that we have highlighted, they've spoken to those recommendations. I also agree that we need to find a way of calling all of these municipalities again in terms of checking the implementation of this. It needs a lot of time. Maybe next year when we open, this should be a priority, that we should have 2 days, whether these 2 days will be through Zoom or we will go to Mpumalanga again. This is something that we can discuss given the time that we have. If you remember when we were there, the municipal manager of Ekangala or what was still kidnapped. It was a big problem. Just when we returned there, a councillor in Mkondo local municipality was assassinated. And as we gather the information, it all relates to internal power struggle, as well as the exposure of issues of corruption and fraud, the same area. And that speaks to what you are saying, members of parliament, including what Honorable Motsama is saying about the role that is played by law enforcement agencies, witnesses, not cooperating, disappearing, and all of that. We need to give this an attention so that out of this, we must have lessons that we learn from this particular process. I suggest we do that. Otherwise, we must accept the report as it is, with a view that we need to make those insertions and follow up the matters accordingly in a form of engaging all the stakeholders in Mpumalanga in terms of Section 106 of the Municipal Systems Act. I suggest this is how we must proceed forward. With that, honorable members, can we move for the, I see a hand, let me just check whose hand is this. It's a legacy hand. Honorable Martha Bartlett.
No, Chair, I thought I was asking for a proposal.
Yes, I was
Yeah, no, I propose, Chair.
Oh, yes. Honorable Bartlett proposed that we must adopt this report Any seconder?
I second it.
Honorable Motsamai is seconding the adoption of the report. Any objection to that? Any objection to that? There seems to be no objection. Any abstention? There is no abstention to that. The report is accordingly adopted. Thank you very much once more, honorable members. Mouse and the team, with all these amendments and additions that we have made, the report is adopted, prepared for Parliament, for adoption by Parliament. And please try to request more time for the presentation of this report, because as it is, you can see that it is much involved. It deals with observations on the provincial government itself of Mpumalanga. It deals with all the law enforcement agencies, SIU, NPA, your Hawks. It deals with all the municipalities that presented to us. There are about 6 or 7, but it also deals with the municipalities that have not presented to us. We need to make some reflections on those municipalities as we were in Mpumalanga. And that requires more time so that Parliament get a clearer and better understanding of the magnitude of the problems that are obtained in Mpumalanga. And through this report, we can better understand what is the situation in Mpumalanga vis-a-vis the invocation of Section 106 of the Municipal Systems Act by different municipal provincial governments, MECs across the board. With that, thank you very much, honorable members. This brings us to the end of our meeting. The meeting is adjourned. Thank you very much.
Chair.
Thank you, Chair.
Who's that?
Chair.
Okay, thank you. The meeting is adjourned.
I'll see you this afternoon at 2. I'm debating. Ready? I'm coming. Numbers.
I was saying thank you, Chair.
I'm waiting for you.
I'm coming for you. I'm ready.
Morning, Chair. Morning, Chair. 03.